Welcome back to the Lost Test channel. My name is Anton Vieltsin, and I'm a criminal defense attorney here in the Southern District of California. Today we're going to be discussing one of my favorite topics, the Fourth Amendment and reasonable suspicion to pull somebody over. Now, the case we're going to talk about is also one of my favorites. The reason why I like it so much is because years ago I had a case that was virtually identical to this one on its facts. I filed my motion, and the case ended up being dismissed by the United States Attorney's Office. So it was a big W for me and for my client.
Knock 'em down, get 'em in. Yeah, you're gonna win.
Now, before we talk about it, I urge you to like and subscribe to my channel. In fact, I'd like you to go to another channel that you subscribe and unsubscribe from that one. And when that guy emails you, go ahead and tell him that you're now subscribed to this one so my channel grows. Thank you for watching, and let's get to it. The case we're going to discuss today is United States versus Sigmund Ballesteros. Now, this is a Ninth Circuit case dealing with the Fourth Amendment and reasonable suspicion to pull somebody over. Before we talk about the law, let's first discuss the facts. I have this map that will assist us with the case, and it will give you a better overview of what happened in this case. We have Highway 86 that goes north to south. It starts approximately in Calexico and El Centro, California, and goes towards Riverside. Now, there is a Border Patrol agent that's sitting in the middle of the highway between the north and the southbound lanes. The way he's positioned, his headlights are shining at an angle towards the northbound lane. This way, it is easier for him to see what's going on inside the vehicles as they approach and pass him by. Now, a Ford F-350 with a camper is traveling north on Highway 86.
Up against this mighty mountain of boulders, we pitted the power of Ford 4x4. But that's not all. On its back, we bolted a weighty 1.5-ton competitor. Now watch as this rugged Ford F-350 pours on the power and answers the challenge. Twin traction, independent front suspension, high ground clearance. Clawing its way to the top in an outstanding display of raw-boned off-road ability. Ford carries the day right to the top. Check out the change in the Ford light truck range now.
It is 4:20 in the morning, so it is still very dark outside. As the F-350 passes by the Border Patrol agent, because of the lights, the driver of the vehicle puts his hands up and partially covers his face. Now, because the Border Patrol agent believes that that's suspicious, the Border Patrol agent decides to make a U-turn and catch up to the F-350. Because he's traveling at a very high speed to catch up to the F-350, the driver, seeing the tailgater, decides to suddenly change into the slow lane. That is according to the Border Patrol agent. At that point, the agent became parallel to the F-350, and he activated his alley light. Now, the alley light is one of those that is operated by a handle, so he can shine it in different directions. He notices that the rear seat is missing from the vehicle. And when they're next to each other, when the Border Patrol agent shines his light into the driver's side window, again, the driver puts his hand up to conceal his face. At that point, the F-350 decided to pull over to the side, to the shoulder of the highway. And only at that point, the Border Patrol agent activated his lights, approached the vehicle, and inside the vehicle, he found 18 illegal aliens. The driver of the vehicle is charged with 8 U.S.C. Section 1324, which is transportation of illegal aliens. In fact, I have other videos discussing 1324 on my channel. It is a very common charge here in the Southern District of California because we're a border district. So you see transportation of illegal aliens a lot. Now, This case is also from the Ninth Circuit, and it is in fact from El Centro, the Southern District of California. Now that you understand what's going on with this case and the facts, let's move on to the law. The Fourth Amendment protects you against unreasonable searches and seizures. When we're talking about searches, usually that means that the officer needs to get a warrant before he searches you. But if we're talking about seizures, the Fourth Amendment says that even those seizures have to be reasonable. What does that mean? It means that there has to be a particularized and objective basis to pull somebody over. Reasonable suspicion. And the officer has to believe that somebody is doing something wrong, something illegal. And the reasonable suspicion cannot be based on broad profiles. So it should not be race or the fact that he's driving in the area that has a lot of criminal activity going on. It can't be broad generalizations. It has to be particularized to that person. Now, we're going to discuss a number of items that the Border Patrol agent believed gave him reasonable suspicion to pull over this vehicle. The first one is that the fact that the vehicle made the lane change and moved off of the road at some point. Now, the Ninth Circuit tells us that the driver of the vehicle had three options. He could do nothing when the Border Patrol agent was behind him. He could have sped up because, after all, the Border Patrol agent was traveling at a much higher rate of speed to catch up to the F-350. Or he could yield. Now, out of the three options, the Ninth Circuit says that yielding to the Border Patrol agent was in fact the most reasonable thing that the driver could do. Not only that, the California DMV handbook on driving tells the drivers of the state that when they have a tailgater behind them, the safest thing to do is move over, and if that doesn't work, to even get off of the highway. So in this case, the DMV told the driver to do that. So he's done something that everyone believes was reasonable. Because of that, the Ninth Circuit says that there was no reasonable suspicion because of this movement.
So I tested it out and counted how many cars did not move over, and of that number, how many were speeding. In just 25 minutes, 100 cars failed to move over. 26 of those were speeding.
Traffic's moving over to one lane. If it's not practical, like the semi-truck may get stuck, as long as he reduces the safe speed as he passes us.
That didn't happen.
There's no reason why it could not have moved over. The vehicle next to it had allowed enough space for that vehicle to change lanes in front of him.
The second item is the hand gestures. Remember, there were 2 times when the driver put up his hand to cover up his face. Now, the Ninth Circuit says that they believe that's different than what the Border Patrol agent believed. After all, the only time the driver put up his hand was when there was sudden introduction of light. The alley lights on the Border Patrol vehicles are much higher than the normal lights on most vehicles. And in fact, there's even laws in most states that prohibit regular civilians to have those lights and other lights that are higher than the headlights. Why? Because if you shine that light into somebody's eyes, you can either blind him temporarily, or that could be very disruptive to the driver. So the Ninth Circuit says that it is the Border Patrol agent who is being unsafe by shining a bright light into the vehicle at 4 a.m. in the morning when it's still dark. The third item is where the route is, and it is commonly used for smugglers. Now again, the Ninth Circuit says that it is a 4-lane highway. There's 2 lanes going northbound and 2 lanes going south. It is a highway that goes from El Centro, California to Calexico to Brawley, and of course it connects to other big metropolitan areas like Riverside. And again, the Ninth Circuit says that this route and this reasonable suspicion would become too broad of generalization. And remember, the Fourth Amendment and reasonable suspicion tells us it cannot be based on broad profiles. So a lot of people use that road, not just smugglers. Fourth, the type of the vehicle. The Border Patrol agent believed that the vehicle was an F-350 with a camper. And he said that this is a type of vehicle commonly used by smugglers. But again, the Ninth Circuit tells us that Ford F-350, a truck, is a popular vehicle even with normal civilians. It doesn't mean that you're doing something illegal if you're driving a Ford F-350. Now, there's a problem that you're not driving a Chevy and not driving a C10, but it is not criminal. E, traffic pattern at the time of day. The Border Patrol agent said that there was little traffic at 4 a.m. in the morning, and to him it was suspicious that you had a truck traveling that early in the morning. But the Ninth Circuit said that the agent and the U.S. Attorney's Office presented no evidence regarding the traffic and how it relates to criminal activity. And in fact, if you're working in Riverside or LA or San Diego, it is commonly that you would wake up at 4 a.m. in the morning to make it on time to your job. So it makes sense that somebody would be on the highway that early in the morning. Next, proximity to the border. Remember, we're talking about El Centro and Calexico. We're dealing with a highway that's really close to the border. But the Supreme Court already told us before that roads near the border carry not only the aliens seeking to enter this country illegally, but a large volume of legitimate traffic as well. So just because you're driving next to the border doesn't mean that you're doing something illegal. And finally, the missing seat. Again, the Ninth Circuit said that there was no testimony or significance about the missing seat. A lot of vehicles, a lot of trucks can take out their seats just to give them more room to put items. If you're working in construction, you might have done that yourself. Now, because none of these provided enough reasonable suspicion, the Ninth Circuit said that the suppression motion should have been granted in the district court, meaning that this stop was in fact illegal under the Fourth Amendment. Now, if you enjoyed this video, please click like, subscribe. Hopefully you now understand the Fourth Amendment and reasonable suspicion and how totality of circumstances and evidence can add up to reasonable suspicion, and in some cases, it doesn't. So once again, subscribe to the channel, and thank you for watching.